The state was, I hope, successful in convincing you that Keith Agee obviously committed first-degree murder. There is no doubt here what he did, as we've all said, horrific, horrendous. He caused such harm to so many people. You'll note, it's interesting to me when Sheila was testifying, she was talking about the harm he did to the Sims family and everything else. And again, no one's making a hero out of Sheila. She did what she did, she said what she said, and we'll get that in a minute. But if you come into this case believing she's innocent, which was such a big thing we talked about in jury selection, if you came in totally clean and you left your minds open and you weren't going to be impressed enough by the first thing you heard that you were going to judge everything by it, then there's also other people that were hurt too. She was hurt tremendously. She lost her son. She lost her new daughter. She lost her grandchild. She lost her piece of life. She's going about her business. She's got a great job. She's working. She's doing her best to get through life. She's got a son that is, you saw him, you heard about him, and you've seen the text. But she's living a life, and this catastrophe happens, okay? So let's back up. The state's proven that Keith did this. They do the same thing in their closing, and they're gonna have a chance to come back, and after I've said everything, they're gonna reiterate it and exploit what I've said. So I ask you again, till the very, very end, keep your minds without a decision till you've heard it, okay? So Keith tells Mom, I'm gonna do this terrible thing, and then you've heard the testimony. He said it numerous times. He's threatened to kill his father. He's threatened to kill everybody. He's gonna do this, he's gonna do that. But he never did. There was that talk about when he was a teenager and he had a thing with another teenager, etc. That's not relevant to you. It may say, well, she should have known he had a propensity and all that. That's history. Remember, every time you think about things here, every text, everything she's doing is to stop this from happening. Again, she doesn't believe he's coming. He's the kind of guy that says these things constantly. He puffs up things that he blisters, and that's him. So she's dealing with work, she's dealing with this, and you've seen the text from, well, let me get there. We back up. Again, Keith did a horrible, crazy, stupid, vile, vulgar thing that affected everybody, okay? It turns lives around, it turned her life around. So let's put it into perspective in the context. She's at work, taking care of these 20, 25 people. She's just been through the last week with him with his nonsense. Is it a vaginal infection? Is it gonorrhea? This you've heard, and I'm not going to put them up. My plan was to put up every single one of those and go over them again with you, just like we did with Sheila. But you're going to have those in evidence. So every time state puts up something like that, just please remember that they're leaving out the whole context. The context is what enables you to understand intent. And so when they argue from their perspective, well, she did this, she did that, she admits that. She didn't come here to say she didn't say those things. She's not even defending them in any other way except I'm his mother. I try and comfort him. I try and calm him down. I try and keep him in line. That's what mothers do. They don't always do it right. Remember when we talked about, I asked you some questions in voir dire, and what I was trying to get you to respond to was, are we all perfect? Do we all respond to situations perfectly? Do we all deal with stress, nonsense, all this stuff? How do we deal with it differently? And we deal with it differently on different days. So there's mom at work, taking care of business, gets the text.
Thank you so much to Marie Pereira for joining us.
All right, folks, stick around. Coming up, more of the defense's closing argument in the revenge mom murder trial for Sheila Agee. Keep it here on Court TV, your front row seat to justice.
Did you take what he said literally?
No, sir.
He said he was coming.
Yes, sir.
Did you think he was coming?
No, sir.
Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. The defendant in the revenge mom murder trial in Florida testified in her own defense today. Sheila Agee is charged with first-degree premeditated murder for encouraging her son Keith to kill the mother of his child because he thought she gave him a sexually transmitted disease.
Now, Keith is serving a life sentence for the murder of Brooklyn Sims. He went to her job at Home Depot, where Sheila Agee worked as well, and shot her multiple times. Today, he was called to testify on his mother's behalf, and he told the jury she had nothing to do with the murder, and she did everything to stop him.
When Sheila took the stand, she testified she didn't know what her son intended to do, and she was trying to steer him away from focusing on Brooklyn and threatening to kill her.
Right now, defense attorney David Ackerman is continuing with his closing argument. Let's get back inside that courtroom.
It was over. Now, you had a chance, and if you'll recall, the state was very content, as they are in closing, to just include that 2 hours of tapes without giving you any insight or feel for what was going on before that. So we have mom at work dealing with stuff, dealing with what she's been through the last week. Thank goodness from the 8th to the 11th, it's over. He's apologizing, he's saying this. He's all over the place. How do you deal with someone like that? How do you figure? Do you know what they're going to do? Even if they say it. So he says this, she says that. Everything she says to him, and please look at the tapes again, the text again, I keep saying that, and understand the context. She is trying to calm him down. This is all Keith. He's not coming. But you never know. The ceiling could fall down. He could come. Because anybody who's rational and intelligent thinks, I don't think this is going to happen in a million years, but maybe. So the conversation goes on, and she's back and forth. I mean, for you to think, in the context of those conversations, that when she said, don't shoot at the car, you might hit me, you've watched her, heard her. Is she serious? The state wants you to think that was, hey man, kill her, but don't kill me. I'm your mother. I'm the grandmother of your kid. I mean, it's insane. And that pulling her out of, he's saying, I'm gonna have to pull you out of the car. Can you imagine how stupid and crazy that sounds? Well, yeah, pull me, don't hit me. You don't want to do this up there where your child is. She's trying to just stop the nonsense. I mean, how in the world would she, where's the plan? So we have all the week before with the text back and forth, not one word about from Sheila, not one word that she's terrible, that this, that, and the other. He's trying to keep him level. And so all of a sudden, now there's a plan. There's no plan, there's no motive. Why in the world would she want favorite kid? Dead. That's how her life is. The grandchild now, and the mother of the child. And why in the world? Oh, because she told Keith, I like her, but I love you, Keith. And I'm gonna help you do this because you're my son. You know, my murder? You from that woman who's telling him all those things about how a lovely life he has, got a child, he's got a future, and she's telling him, yeah, go kill her. I'm gonna step aside here. The state says she guided him like a bullet. All that stuff to get your juices flowing. If you listen to what was said, that's the opposite of what she wants. We've all been sarcastic. There are different words to describe it. We don't always say exactly what we mean because we want someone to be, we're all trying to get someone to go to our side and manipulate them to stop being fools or something. Give up your life, son. Shoot somebody. Come on down here. Shoot somebody right in the middle of the day, in the middle of a store with cameras and everything else. Yeah, do that. I'll be waiting for you. Guess I want to watch. Where's the motive? What is this? What are they trying to say? Here's what they're trying to say. We've got these texts. And remember, that's all they had for a minute, for a moment, whatever for it. So if you take those texts out of context and you don't know anything about anything else, then, yeah, that's a mother who thinks her son's been wronged, and she's going to go after this person who wronged her. She doesn't think her son was wrong. She thinks he's ridiculous. I mean, it's difficult to make. Some of us see things from different perspectives, and that's human nature, and that's what we've been talking about here. To me, the case for Hugh was proven more so than the case against you. Why would she want him to do this? And even if you say, well, she was just stepping aside, as the state will say, where does that come from? 50 times? 40 times? What are you doing, son? What are you doing? She's a good mother. She's a good person. And you're here making all of these ridiculous statements and allegations. One minute she's terrible, next minute she's great. I want to have a relationship with Casey, so I'm going to be a good boy. I'm putting this all past me. You'll see that in the text. Please, if you still have questions after this, when you go back to your room, study those texts. They are not from somebody who is saying, yeah, let's get together and do this. No motive. The opposite. No plan. If there was a plan, would it be by text? Wouldn't there be a phone call? I'm going to meet you. The state saying he walks right in, he goes right to the aisle. He doesn't walk in and go where he thinks he walks in the aisle, he goes right up to the front of the store, and he's looking down each aisle, and he looks, and he sees her. Is there some kind of... Are they trying to say that they can't? That she told him there's no phone calls, there's just the text. So he finds her there on that aisle. Okay? No plan for her to get there or anything else. She finds it. As far as coming here, she looks at you when she was asked that question, me and everybody else. And the state asks Keith, you would not have known where to go unless she told you. No, I wouldn't. Not trying to fudge or hide anything. And again, Keith's not the ideal witness. Nobody wants to call a murderer to the to the trial of someone accused, who's supposed to be a principal. You watched his demeanor. You watched him. All I can say is what he said to you, and what clear to all of us, that there was no collusion between the two. Nothing he said, this is the way. Nothing he said indicates one iota that he was motivated by mother, induced by mother, etc. by mother. Everything was, don't do this. And again, the state wants to say, but you never said don't do it. He's a contrary guy. You don't confront them with that. You go around it. You say this, that, and the other to convince them not to. But this whole concept that mother wanted this to happen, again, you take it out of context with just those 4 or 5 words, but you also take out of context from the 40 words that she didn't want this to happen. And we're going to go through reasonable doubt in a minute. But if you weigh these statements here, and then you weigh in the conversation prior to this, you will see that there's absolutely no proof beyond it to the exclusion of every reasonable doubt that she wanted Keith to commit this heinous act. It's not there. Very difficult when you're accused of something and you've done stupid things or said stupid things, or what is stupid to others, but to you at the time. It's very difficult to defend that. I mean, every one of us, if you take out of context what we've said or done at a certain time, did you say that? What did you mean? Well, and then you explain it. Oh. Intent. That's the key word here. We all agree. I mean, state put on that wonderful case against Keith. We sat there all through it. Very few objections from me, a few things, if you remember.
So, Judge, what he's saying basically is if the texts don't fit, you must acquit.
Yeah, oh my gosh, Michael, you said it. I can't believe you went there, but I don't disagree. That's exactly what he's saying. There's no motive, there's no intent. That's it, the text.
Yeah, they said texts don't lie. He's saying they do.
Yep.
All right, we need to pause it there for a quick update out of Kentucky. It was sentencing day for one of the 3 men convicted in the killing of Crystal Rogers. Rogers vanished on July 3rd of 2015, and her remains have yet to be found.
Last May, a jury convicted Stephen Lawson of conspiracy to commit murder and tampering with evidence in the case. That jury also recommended that he be sentenced to 17 years in prison. Before sentencing, the court heard from the victim's family.
I want to ask you to look at Crystal's family, look at her kids, look at Sherry. And don't you think they need to know where their mother's buried so they can have peace and at least lay their mom to rest the way it should be done? And they deserve that. Wouldn't you want that if it was your mother or your daughter? Then you need to stand up, be a man, and do the right thing, because you're going to prison. But if you do one right thing in your life, this is the thing to do. Let them know where their mom is.
You could have told the truth. My dad would still be here if you would have told him the day you met with him and my brother. You knew what was happening. You had the power to stop it, but you stayed silent. Your silence took Crystal's life and my dad's. You chose evil, and evil never wins. Because of your choices, Crystal's children grew up without their mother. We all face milestones without her. You took away her future. For what? Money? Olive Brooks' drywall jobs? Things you did not have and things you'll never have. You took away a life because of greed and selfishness. I hope every day you spend in prison reminds you of what you did and who you destroyed. I hope the weight of the truth sits heavy on you.
The judge went along with the jury's recommendation and sentenced Lawson to 17 years in prison. Now, his son, Joseph Lawson, and Roger's boyfriend, Brooks Houck, were tried and convicted in July, and they're going to be sentenced on August 21st.
All right, let's take that break now. When we return, we will head back to Florida for more closings in the revenge mom murder trial of Sheila Agee.
And in Montana, the case against accused killer Jordan Palmer is close to wrapping up. Hear what one defense witness had to say about what Palmer could have done but didn't have to do when confronted by the victim. Keep it here on your front row seat to justice.
Saturday nights on ION
is our night.
Let's go! Double headers every Saturday at 7 and 10 p.m. Eastern. The new Saturday Night Out is on ION all season long.
These are the cases that captivated the world.
Couldn't keep my life straight.
They were killed by their own children.
That challenged the legal system and ourselves. Court TV, Legendary Trials.
Get you back to court in just a little bit, but first we have this update in our other big trial, the returned mail murder trial of Jordan Palmer. He claims he was defending himself when he says his neighbor, Stephen Campbell, threatened him and took a swing at him back in April of 2024.
Palmer told police that he was putting a piece of mail that he found on the ground into the correct mailbox when Campbell confronted him. The state, however, says that surveillance video from that day does not support Palmer's claims of self-defense. Today, the defense continued its case and called on a use of force consultant to testify about evaluating a threat and when and if you should try to de-escalate the situation. Let's take a listen.
Even in policing, is anyone trained to de-escalate an ambush?
Not verbally, no.
And is there, based on your review of the evidence in this case, do you think that Mr. Palmer was required to have done more de-escalation than what he did?
Well, I'm getting stuck on the word required. I don't think anyone's required to do de-escalation. I think it's a gift you give the other person. It's saving them from the consequences of their bad decisions. So de-escalation is what we do, again, to save them from the consequences of their bad decisions. So I don't think he was required to. Were there opportunities to initially? Even under those circumstances, even as they came out in this case, the best de-escalation, the most competent de-escalation people, that window closed very quickly.
The defense is expected to finish its case today or tomorrow.
All right, I want to get you back to Florida now for more of the closing arguments in the revenge mom murder trial.
Ran the videos at the Home Depot, and you listen to his testimony, and sure, because one would think that there's cameras all over the place, and that people who work there would know where they were. Did Sheila have any idea? Is there any way she would know where the cameras were? No. So please, if there's any thought about aisle 52 and no camera, Sheila had no knowledge of cameras. You saw the video of Keith pulling up. I think the state said something about he pulled up alongside Mom. First of all, he probably didn't know what car she was driving. We didn't hear testimony, I don't remember, but she drives different cars all the time, and she drives a company car. He doesn't know well enough, and you can see by the conversations, he doesn't talk to Mom every day, doesn't see Mom every day. They text a lot when they text, but he comes right off the road, pulls right into a spot. And he was not right next to her car, he was about 2 or 3 cars away. But there's no evidence that he knew where her car was or that was her car. So he pulls in, he walks down, and you see him on the video do his thing, goes down the aisle. You saw her waiting, I'm gonna guess 30 minutes plus or minus, maybe 40 minutes, walking back and forth back and forth. She's waiting for him if he's coming. She's not sure. She ends up, after all that time, my gut feeling was right, he's not coming. This was all typical Keith. So takes a breath, goes back to work. Still probably, looking over her shoulder once in a while. Wasn't long. He gets there, walks right down the aisle. Whatever, that one. I don't know, maybe it's just me, but look at this picture. This is a still from those videos. And I'd ask you to maybe, would you take a quick look and just pass it around? Look at the expression on the face.
Here with us now to discuss is trial attorney Wendy Patrick. Wendy, of course, thank you for being on with us. Listen, I find that the defense attorney is a little bit hard to follow, but there was a nugget that he said that I pulled out of it, and I really wish there was more emphasis, and that is, where's the motive? What are they trying to say? Remember, that's all they had. They take the texts out of context, and I think that's the heart of the case for the defense.
I agree. That's the takeaway I had as well. Context counts. That really defines the job for the jury, is they're going to have to decide whether a murder was planned by text message to the extent that both mother and son understood exactly what she was coercing him to do. That's hard. And that's one of the reasons the defense attorney appeared a bit awkward as he was attempting to not break the golden rule and ask the jurors to put themselves in the position of the defendant, but going as close as he could to talk about what he was arguing is an unreasonable interpretation of the evidence. So he was dancing around that line. And, I feel for him. I've been on that side too. It's difficult to try to do that because we all know those jurors don't have any context within which to understand what happened. I mean, they all have mothers too. They can't imagine that such a thing could happen. But remember, that's not the key. They're not putting themselves in that position. They have to understand where the evidence goes and whether it means this defendant actually did that. So he's doing the best he can. It was hard to follow, but at the end of the day, they probably didn't need much of his commentary because they're already thinking through whether or not they believe those text messages can actually prove the motive beyond a reasonable doubt and the intent. You don't need to prove motive to prove murder, but the intent beyond a reasonable doubt.
Wendy, we talk so many times about how these cases are won and lost in jury selection. I think this is one of those cases. Notwithstanding what you said, because that's absolutely the law, you can't, as a juror, put yourself in place of the defendant. But that's really, as a defense attorney, what you want them to do. But they need to understand what type of mother this was. I think that's the key. She's parenting different than a lot of people on the jury. But hopefully in jury selection, you found one or two people who can understand this type of situation that she was in, some of the dysfunction that she grew up in, and the choices that she made. Because again, the context isn't there, but you kind of have to look beyond the text messages to find her not guilty.
You would definitely need to interpret the text messages differently. That is the challenge. And I'll even add another layer. Sure, it's best if we have motive, even though technically we don't have to prove it. But not everybody requires an understandable motive to commit murder, to commit terrible, heinous crimes. We often say senseless violence. Guess what? The violence often makes sense to the perpetrator in a sense that we would never be able to understand. This could very well be one of those cases. But you have to convince all 12 of that. And that's a hard sell. Not that it's insurmountable. And, you heard a lot of evidence here, but there has to be somebody on that jury at least is thinking, how in the world could that really have been the plan that was so blatantly and somewhat clumsily articulated on text message. That's what you worry about when you're a prosecutor. Even when you have an enormous amount of evidence, you worry that to one of those jurors, even though they know they're not supposed to put themselves in the place, that they might do it. Now, on the other hand, they're going to bend over backwards to make sure they don't.
Fair enough. And let's remember that first trial was dismissed, but my understanding was it was 11-1 in favor of conviction.
Yes.
When the whole juror brouhaha came up, that led
That's
to the
my
dismissal.
understanding as well.
Yeah, so we'll see how it plays out. Let's take a break here. Wendy, stand by. We do need to step aside. The defense attorney continues his closing argument in the revenge mom murder trial after the break.
Also, we will have the latest in the dismembered mom murder trial in Georgia and how one official testified about how they were finally able to identify the victim's remains. Keep it here on your front row seat to justice.
Is there anything in any of these texts that you said to encourage him, motivate him, or do anything to come harm Brooklyn?
I would never do that. I would never want Brooklyn harm.
All right, welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're getting you back to our coverage in the revenge mom murder retrial of Sheila Agee. She is accused of encouraging her son Keith to kill his child's mother. Her name was Brooklyn Sims. Now, Keith claimed that Brooklyn gave him a sexually transmitted disease.
During testimony today, he told the jury that his mother did not encourage him to kill Brooklyn. Instead, he said he was acting on his own and that no one could have stopped him. Sheila, the defendant, also testified, echoing the testimony of her son and saying that she loved Brooklyn. The jury will soon weigh their testimonies.
But first, of course, they have to listen to the final arguments from both sides, and that's what we're doing now. Let's get back into court for more of that.
Again, maybe it's me. I've been around a long time and looked at a lot of expressions and heard a lot of things. That's not a happy face. That's not a face of somebody who's walking up and down the aisles waiting for somebody so that somebody can commit a heinous crime. That's the face of an angry, distraught mother waiting for her son to come, who she said, "You're gonna come, you're gonna see me. And you're gonna have to shoot me." A mother who's controlled her son for the most part over the years. Nothing like this was even in the remotest of her mind. He's saying the same old nonsense, but now he's pushed it. I've just spent an hour and a half on the phone with this guy, trying to reason with him, trying to be the mother that I'm supposed to be, and then he's telling me I'm an MF. And, you know, this is a great little chance for me to switch it. It's no longer going to be me. You called me an MF? You come see me now. It's not her anymore, it's me. Again, an attempt to mollify it, to change his mind, manipulate him so that he's not going to do this stupid thing. I mean, it's, to me, clear as day. This is evidence for you. You're going to bring it back along with the other evidence that I encourage you to look at. We had the ballistics and all of that, and you know, it was very thorough and very good. And the state, you know, if they're going to charge Sheila with the murder, they have to prove the murder. So, you know, all that stuff, we just, you know, yes, we know that. We're not here to say that. We're here to say today that everything Sheila did was not with an intent for anything harmful to happen. And that's the key to this case. Intent. The state, and unfortunately I can't read my own writing most of the time.
All right, so that defense attorney is struggling with his own writing.
Yeah.
Not the best in the world, but at the end of the day, before we go to break here, folks, we have an update in day 2 of testimony in the dismembered wife murder trial of Nicholas Casotis going on in Georgia. He's accused of killing his wife, Mindy, back in November of 2022 and scattering her remains in a wooded area.
Hunters found those remains and officials identified them months later. During testimony today, a GBI special agent testified about how they were able to use genetic genealogy to positively identify Mindy.
So during the testing, they were able to basically build a family tree with connections to potential family members of the victim, and she was identified as a possible mother.
Okay. And only if you know, do you know if they ultimately were able to collect a DNA sample from Mrs. Betsy Mebane?
Yes, we were.
Without them being able to do the forensic genetic genealogy, is that why you went to gene by gene?
That's correct.
Did that ultimately provide you with identity for the purposes of knowing who that torso and the rest of the remains belonged to?
Yes, it did.
And who was that?
Mindy Mebane Casotis.
Casotis was arrested a short time later. Officials found him in Pennsylvania, where he was living under a different name.
Court TV legal correspondent Kelly Craft is covering the trial, and we'll have a live update from the courthouse in our next hour.
Let's take that break now. Up next, more of the defense's closing argument in the revenge mom murder trial when Court TV Live returns.
A woman's remains found scattered throughout a 3-mile area.
Now, a former naval officer stands trial accused of killing his wife.
The dismembered wife murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, the lives of 4 sorority sisters cut short in a tragic car accident. Now the driver is facing murder charges. We're bringing the latest from today's hearing.
Closing Arguments tonight at 8/7 Central on Court TV.
And her mother didn't deserve that. TT didn't deserve that. Aiden didn't deserve that. And Casey didn't deserve that. If I could change this, I would change it. Because Brooklyn was, nobody's perfect, but she was so close.
We'll get you back to court in just a moment, but first, here are other cases that Court TV is tracking.
In Kentucky, a former Kentucky sheriff charged with first-degree murder in the shooting death of a judge will be in court next week. Attorneys for Mickey Steins have filed a motion to dismiss, a motion for bond, and a motion to unseal Steins' psychiatric evaluation. Steins is planning to use an insanity defense. A hearing is scheduled for August 15th.
In Indiana, the judge in the Misty Noel theft and tax evasion case is now leaving her plea and sentencing in place. The judge had threatened to reject her plea after she did a television interview prior to sentencing, saying that she did not knowingly commit the crime. The judge held her in contempt and scheduled a hearing for next Tuesday, but has now dropped the case. Noel pled guilty to stealing public funds to support her extravagant lifestyle. She was sentenced to more than a year in prison and ordered to pay $700 in restitution.
And in California, the defendant in the sorority sisters murder case pleaded not guilty during his arraignment today. Frazier Bohm, who is represented by Karen Reed's attorney, Alan Jackson, is accused of speeding on the Pacific Coast Highway in Malibu, losing control, and crashing into 4 Pepperdine University sorority sisters back in October of 2023. Court TV anchor Julia Janae spoke with one of the victim's friends about the tragic loss.
Asha was wise and gentle. Neve was just joyful and such a light and so kind. Peyton was so driven and just selfless and just the best. And Deslyn was always the life of the party. She was like the confidence. She was your confidence when you didn't have it. They had so many aspirations, so many goals. They were going to go so many places, and it's truly heartbreaking that their lives were taken too soon.
Bohm will be back in court on September 5th for a pretrial hearing.
All right, we want to get you back into court in Florida, but I just want to mention before we go back in, the clock is up because we are bringing you all of the closing arguments, but the jury has now begun deliberations. We've got about 3 minutes, 48 seconds on the clock. We'll keep that up on your screen. In the meantime, we're going to go back in. The defense is still in closing arguments. Let's go together.
Is there a conscious, on her part, desire for the act of murder to occur, for these acts to have occurred? Now, I've read you those definitions, but here is the final one, that if the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if she had done all the things the other person or persons did, if the state proved beyond a reasonable doubt, not just beyond a reasonable doubt, that the defendant intended the crime to occur. And the defendant did some act or said something that was intended to, and that did, intended to, and that did, incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. And the state is saying she gave him the address. She told him, if you don't kill her, you're a... She said, don't shoot because you might hit me. Do it here, do it there. Obviously, if you think that with what Sheila did that day, August 11, 23, if you think when you read those texts and the text before, and you put everything in context, then if you think that she wanted this to happen and aided and abetted it happening, then she's a principal. But if you're not convinced beyond a reasonable doubt, it's not just, well, you know, she said those things and it's terrible, and then, you know, maybe she intended. That's not enough. You must be convinced. This is our backbone of our law, beyond and to the exclusion of every reasonable doubt, that that was her intent. The evidence you've heard is just some words, and the state aggrandizes them. She said stupid things when you come back to the end result. She wishes she'd have done it differently. Goodness only knows she wishes she'd have done it differently. But that's not a crime. That's not a crime. The next instruction is plea of not guilty, reasonable doubt, and the burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe, coming in here, she's innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything.